Hi to Dr. Hema. Today our group will be talking about the development of medical negligence both in the United Kingdom and Malaysia. My name is Nur Husna and I'll be starting with the definition of negligence. Firstly, what is negligence? Negligence is a failure to take reasonable care to avoid causing injury or loss to another person that a reasonable prudent person would have done in a similar situation. For example, car accident, slip and fall cases, personal injury, and lastly, medical negligence. Now, we need three particular elements to complete negligence, which is the first one is duty of care, the second one is breach of that duty, and lastly, consequential damage. Now, let's move on to omission. Omission is where a party does nothing at all or omission fails to make things better. But some situations are exceptional for omission, where there is a special relationship between the parties. For example, a doctor and a patient. This relationship gives rise to a duty of care. Now, let's go slightly deeper into medical negligence. The defendant should be compared with a reasonable person of the same status and specialism. You cannot compare a general practitioner to the same standard as a consultant neurologist. They are both different in every way and there is no single right way of proceeding. For example, one doctor might recommend surgery to a patient, but another doctor might just recommend taking medication. The court also requires that the defendant has to act in a way that will be supported by a body of respectable medical opinion. This means a doctor is not guilty of negligence if he has acted in accordance with practices that are accepted by responsible body medical men skilled in that particular area. Ultimately, in medical negligence, the standard of care is not varied according to the level of expertise of a doctor, as it would mean that the care of patient can also be dependent on the experience of a doctor who treated them.
My name is Janie Ravindran, and in my part, I will be talking about the Boehm's test. In general thought of negligence, it is the judiciary that determines issues regarding a breach of standard of care. However, in the Boehm's test, whether or not a medical professional has fallen below a particular standard of care in his treatment is in accordance with the opinions of a responsible body of medical professionals. Essentially, the Boehm's test evaluates the appropriate standard of reasonable care in medical negligence cases. The Boehm's test was developed in the case of Boehm against Friern Hospital Management Committee in 1957. That the plaintiff, John Hector Boehm, wanted to sue the defendant, Friern Hospital Management Committee, for medical negligence. The plaintiff went through electroconvulsive therapy, however, was not informed of the risk of a fracture and procedure was carried out without a relaxant drug. Both hip joints of the plaintiff were dislocated with fracture of pelvic bones on each side. The plaintiff intended to claim for damages for injuries against the hospital management for negligence as there was a failure to use relaxant drug and risk was not informed of. However, in order to claim for negligence, a breach of duty had to be established. It meant that the defendant had to fall below a particular standard of care. It was held that the doctor was not negligent. Justice McNair had made a statement stating that a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable body of medical men skilled in that particular art. In other words, the Boehm's test states that if a doctor reaches the standard of a responsible body of medical opinion, he is not negligent. Since then, the Boehm's test has been applied in several cases, such as in the case of Sidaway against the Board of Governors of the Bethlehem Royal Hospital and the Maudsley Hospital. In this case, the plaintiff suffered from persistent neck pain and shoulder pain, hence had employed a surgeon at the hospital and had been advised by him for several years now. The defendant advised her to undergo an operation on her spinal column to relieve the pain. He informed her of the possibility of disturbing a nerve root and its possible consequences, but did not inform her of the possibility of a spinal cord damage. The risk was assessed to be at least less than 1%, but the resulting injury could be very serious. The plaintiff consented to the operation and it was carried out. After the surgery, the plaintiff suffered an injury to her spinal cord which resulted in severe disablement. She sued for damages, alleging that the surgeon had negligently failed to inform her of the risk involved of the operation, hence she could not give informed consent. The Court of Appeal held that the doctrine of informed consent does not apply in England, and the courts applied the Boehm's test following the statement of Justice McNair. All 4 out of the 5 lords agreed on applying the Boehm's test, except for Lord Scarsman. Lord Scarsman stated that the Boehm's test should not apply in the issue of informed consent, and that a doctor should have the duty to tell the patient of the inherent and material risk of the treatment proposed. Another case that applies Boehm is the case of Gold against Haringey Health Authorities. However, as time went on, it was found that the Boehm's test was not applicable or fair in many situations. One major issue was that Boehm's allowed for dangerous medical practices to continue. It was said to be overprotective and differential towards doctors. The test seemed to deprive the courts in making essential changes in professional standards. It gave an impression that the courts were being dictated rather than being able to exercise their own judgment. Due to this, the profession may adopt unreasonable practices. Boehm's did not necessarily protect the community from unsafe medical practices. However, it was more likely that a patient's concern was dismissed in favor of the doctor. Another issue with Boehm's was that it gave an impression that the medical profession was above the law. The standard of care required by the medical profession are regulated solely by the medical professionals and not the court. The decision of the outcome did not lie in the hands of the court. The opinion of a medical expert should be no different from the analysis of a judge who would make decisions for other professions. Hence, it was questioned that if a court could be the final arbiter for other professions, shouldn't it be the same for the medical profession? In order to overcome these issues, a new addendum had been introduced in the case of Belito against Hackey and City.
I am Naomi, and I will be talking about the relevance of Belito versus City and Hackney Health Authority 1997 in discussion of the Boehm test, within which modern medical negligence laws remain prevalent. This landmark case has offered vital guidance on how the Boehm test is used, representing a significant development in the way courts assess medical malpractice and weigh professional independence against patient well-being. This case involved 2-year-old Patrick Belito, who had brain damage as a result of cardiac arrest due to respiratory failure after the doctor in charge of the matter never received her summon due to a low battery on her bleeper, which led to the death of the child as a result. The speech by Lord Brown Wilkinson in the leading judgment of this case has potential implications for the way in which the Boehm test might be interpreted, stating, "The court has to be satisfied that the exponents of the body of opinion relied upon can demonstrate that such opinion has a logical basis." In particular, in cases involving, as they so often do, the weighing of risks against benefits, the judge, before accepting a body of opinion as being responsible, reasonable, or respectable, will need to be satisfied that, in forming their views, the experts have directed their mind to the question of comparative risks and benefits and have reached a defensible conclusion on the matter. End quote. The mother decided to sue for negligence, arguing the child should have been seen and intubated. Thomas Phillip advocates and solicitors wrote in their article, "The Standard of Care in Medical Negligence Cases, What Has Led to Where We Are Now." It states that the Boehm test, qualified by Belito, sets out the standard of care regarding the duty to diagnose and treat, meaning a doctor would not have breached his duty and standard of care to his patients as long as he acted per a practice acceptable as proper by a responsible body of doctors, and that his actions can withstand logical analysis. The central legal issue was whether or not non-intervention by a doctor caused the plaintiff's injury. The defense argued that even if the doctor had arrived, it would not have been standard protocol at the time to intubate the child, which led to the decision by the House of Lords that the defendant did not cause a breach of duty, as refusing to intubate the child was not an illogical decision. This case led to the House of Lords clarifying the Boehm test to include that the practice accepted as proper by professionals must be based on reasonableness and logic. Belito added the ability to ensure that courts could place scrutiny upon expert evidence and required that medical practices must be supported by logic to ensure professional autonomy will not override the safety of a patient. In Ash Samantha and Joe Samantha's paper, Legal Standard of Care, A Shift from the Traditional Bolam Test, 2003, they stated that the court will take a more inquiring stance to test the medical evidence offered by both parties in litigation in order to reach its own conclusions. Recent case law shows how the court has applied the Bolitho approach in determining the standard of care in cases of clinical negligence. An understanding of this approach and of the shift from the traditional Bolam test is relevant to all medical practitioners, particularly in a climate that is increasingly litigious. The case granted judicial oversight, as a lack of reasoning would allow courts to reject invalid medical opinions and provide higher levels of accountability in medical practice, making sure that there would be no protection to negligent doctors, creating the move towards a patient-centric approach, which enforces the duty to provide care logically with medical knowledge. It acted as a protection against solely depending on expert opinions, guaranteeing that patient safety come first. This change not only increased responsibility in medical care, but also emphasized the judiciary's involvement in maintaining a balance between professional decision-making and patient rights. Bolitho's assurance to a balance between respecting professional judgment and protecting patient rights reiterates the Bolam test's relevance as we see its continuous adapting worldwide, as a shift towards patient-centric standards are done. Bolitho's emphasis on logic remains globally influential as professional standards and patient welfare are balanced, further shaping the laws within medical negligence to ensure a standard of care.
I'm going to be covering the case Chester v. Offshore. So a little background of the case: Miss Chester, the claimant, sought treatment for back pain and was advised to undergo spinal surgery to alleviate her condition. The procedure was carried out by a highly skilled and experienced surgeon, Mr. Offshore. While preparing for the surgery, Mr. Offshore failed to disclose a small but a significant risk, specifically a 1 to 2% chance of paralysis as a potential complication of the operation. The surgery itself was performed without any negligence in its execution. However, the inherent risk materialized, and Miss Chester suffered paralysis. This complication was not the result of any error by the surgeon during the procedure, but rather a known and unavoidable risk associated with this type of surgery. The key issue in this case arose from the lack of proper disclosure, and Miss Chester argued that she was deprived of the opportunity to make an informed decision about whether to proceed with the surgery or to explore other alternative options. So, the central issue was whether the surgeon breached their duty of care by failing to inform Miss Chester of the inherent 1 to 2% risk of paralysis, despite the fact that surgery itself was performed completely fine. The question revolved around the surgeon's obligation to disclose material risks to allow the patients to make an informed decision. The House of Lords ruled in favor of Miss Chester, concluding that the surgeon's failure to disclose the risk constituted a breach of duty. The court emphasized the principle that a patient has a right to be informed of all material risks associated with the procedures, no matter how small, as these risks could influence their decision to proceed with the surgery. The decision established that the failure to provide such information undermined the patient's autonomy and the right to make informed healthcare decisions. I also want to cover some key principles from the case. One of them is the patient autonomy. The ruling reinforced the principle that patients must have the ability to make informed decisions about their own healthcare. Doctors are required to disclose all relevant risks, even those with a low likelihood, so patients can weigh the potential outcomes and choose what aligns with their values and preferences. Another key principle is material risk. A risk is deemed material if it is significant to a reasonable patient, or if the doctor knows that the specific patient would consider it important. The court emphasized that what is material depends not only on the likelihood of the risk, but also on its potential impact on the patient's decision. So basically, this case set a precedent that clarified the legal obligations of healthcare providers to ensure informed consent, prioritizing the patient's right to autonomy over professional discretion and risk disclosure. Another thing I also want to cover is the impact on the Bolam test. The case Chester v. Offshore introduced a significant limitation to the implication of the Bolam test in cases involving informed consent and risk disclosures. Traditionally, the Bolam test allows courts to defer to a reasonable body of medical opinion when determining whether a medical professional's actions were reasonable. However, in Chester v. Offshore, it demonstrated that the disclosure risk is distinct from clinical judgment and cannot be evaluated through the Bolam standard. So, would Miss Chester still would have undergone the surgery? The court acknowledged that Ms. Chester did not argue she would have completely avoided the surgery if warned of the risks. Instead, she stated that she might have sought further advice, like a second opinion, and considered her options, or at least delayed the surgery. This delay could have allowed her to make a more informed decision or have the surgery performed by someone else at another time. By failing to warn Ms. Chester of the small but serious risk of paralysis, the doctor deprived her of the opportunity to weigh up those risks for herself. This lack of disclosure interfered with her autonomy, her ability to make an informed decision about her own body and health. A major challenge in this case was causation, how the breach of duty, which is failure to disclose the risk, directly caused Ms. Chester's paralysis. The traditional approach to causation requires showing that the harm would not have occurred but for the breach. However, Ms. Chester could not prove that she would have avoided the surgery altogether if she had been informed. Despite this, the court found in her favor by taking a fairness-based approach to causation. The decision emphasized that failing to inform patients of risks undermines their autonomy, and in such cases the law should step in to provide a remedy. So, in conclusion, the House of Lords ruled that failing to disclose a material risk breached that duty of care, even if the medical procedure itself was completely performed fine. This emphasized the patient's right to make an informed decision. The case reinforced informed consent and patient's autonomy, ensuring that risk is disclosure and is a fundamental legal obligation separate from clinical expertise. And that's all. Thank you.
Good day, Doctor. My name is Sanchana, and I'll be taking you through the development of the Bolam's test in terms of the case of Montgomery v. Lanarkshire Health Board and its developments from there. So far, we have visited the cases where the principles of the Bolam case were applicable. So now we're going to look at a case where the Bolam's test for consent was replaced with different conditions due to the nature of this case. And this case that we're talking about is, of course, Montgomery v. Lanarkshire Health Board. Basically, a baby was born in a hospital with several disabilities, including shoulder dystocia and cerebral palsy. Shoulder dystocia is basically the inability of the baby's shoulders to pass through the pelvis. Our plaintiff in this case, which is the baby's mother, was seeking damages against her obstetrician, who was in charge of taking care of her during her pregnancy and was also in charge of the delivery of the baby. The plaintiff claimed that she would have requested for a cesarean section had she known of the risks of this delivery. According to her, she should have the right to know of any potential complications that may arise during the birth of her child. The Supreme Court in this case held that Ms. Montgomery was owed a right to be informed of the shoulder dystocia, with the risk of this shoulder dystocia being from 9 to 10%, which is quite significant. She also had the right to decide on which risks she was willing to endure before going through with the procedure. This is where the Bolam test for consent, where the actions of the defendant during any procedure in question had to be considered as an approved practice by a respected body of medical opinion, was replaced with a new test where the materiality of risk involved during said procedure has now to be assessed by a reasonable person who is in the shoes of the patient. So in this case, it could be argued that a reasonable person would want to be informed of any risk involved when consenting to any sort of medical procedure, especially if their newborn baby may be affected and if the risk of said procedure is very high, which in this case it is 9 to 10%. As a result, medical professionals are hence obliged to reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatment. To simplify the sentence, it is the duty of every medical professional to inform patients of any risk that any reasonable person in the place of the patient may find significant. So let's take a look at the effects of the case on the development of the standard of medical care. The ruling by the House of Lords for Montgomery v. Lanarkshire Health Board was successful in overturning the precedent of standard of care when it comes to informed consent, as established earlier in Sidaway v. Board of Governors of the Bethlehem Royal Hospital. So right now, standards of a reasonable person are prioritized over what a doctor thinks or deemed is approved practice. So Montgomery has since then been applied in various cases such as Spencer v. Hillingdon and HS Trust in 2015. So now we're going to take a look at a recent development in assessing the standard of medical care that can be seen in a new test that was established in the case of Khan v. Meadows in 2021. So basically, this test was said to be a helpful model for analyzing the place of the scope of the duty of principle in the tort of negligence, which was stated by Lords Hodge and Sales, with whom Lord Reed, Lady Black, and Lord Kitchen agreed. So we're going to go through very briefly on all 6 steps of this new test. So the actionability question is the first step, posing the question whether the subject matter of the claim is actionable under negligence. The second step is called the scope of duty question, assessing the risks that may harm the claimant that the defendant is legally obliged to assume responsibility towards. The next step, the breach question. Did the defendant breach his or her duty by his or her act or omission? The fourth step is called the factual causation question, where is the loss for which the claimant seeks damages caused by the defendant's act or omission? The fifth step is the duty nexus question on whether a significant enough link exists between the subject of the duty of care owned by the defendant and the loss suffered by the plaintiff. Is a particular element of the harm for which the claimant seeks damages irrecoverable because it is too remote, or because there is a different effective cause in relation to it, or because the claimant has mitigated his or her loss or has failed to avoid loss which he or she could reasonably have been expected to avoid. This is the last step of this test, called the legal responsibility question. So although this model was not consulted or used when producing the verdict of this specific case, Candy Meadows, it remains a derivative and an expansion on the principles brought up in Montgomery v. Lanarkshire on the standard of informed consent we should hold a medical practitioner to. So now the question remains, is Bolam still alive? So it was explained in a journal article named The Effect of the Montgomery Judgment on Settled Claims Against the National Health Service Due to Failure to Inform Before Giving Consent to Treatment, that the Bolam test was rejected and replaced with the Montgomery test of what a reasonable person would want to know rather than what a board of medical professionals deem as approved practice. We interpret this rejection only in terms of informed consent, which is what exactly was replaced by the Montgomery's test. This still leaves the test of general standard of care to Bolam. This answers our question on whether Bolam is still applicable, which is a definite yes. So the case that re-established Bolam's test under the standard of medical care was none other than McCulloch v. Forth Valley Health Board in 2023, where Mr. McCulloch had died following a cardiac arrest. The plaintiffs, who were family members of Mr. McCulloch, brought this case to court on the basis of negligence, where they argued that the cardiologist employed by the defendants was obliged to inform the deceased on the possibility of taking non-steroidal anti-inflammatory drugs in reference to the ruling in what happened in Montgomery's case. However, this appeal failed, given that the doctor's decision to not prescribe the drugs was reasonable, because according to her professional opinion, she did not regard it as appropriate to be prescribing these drugs to Mr. McCulloch. This act was also approved by a board of medical professionals. So the Supreme Court had further confirmed that the Bolam's test was indeed relevant in this case. So in conclusion, it is very clear that the Bolam standard of duty of care still applies to this day. That's all from me. Thank you.
Good day, Dr. Hema. My name is Ariana, and today I would like to take you through the case Rogers v. Whittaker 1992, which is a landmark case in which the Australian High Courts depart from the Bolam's principle and sets a precedent that primarily applies in the field of non-disclosure of risk and provision of advice and information, in which the courts would set the appropriate standard of care. The facts of the case are as follows. Mrs. Whittaker had been almost completely blind in her right eye since she was 9 due to a prior injury when she was a child. She had an eye examination nearly 40 years later in 1983. It is interesting to note that the only reason she had this eye examination was because she was re-entering the workforce. She had previously taken a 3-year hiatus to take care of her injured son. She was referred to another doctor by her general practitioner, and that ophthalmic surgeon in turn referred her to Dr. Rogers, the defendant. On the 22nd of May 1984, it was the first meeting between the plaintiff and the defendant. The plaintiff was advised to undergo a surgery which could improve the appearance of her right eye or her bad eye and potentially restore vision in the aforementioned eye, in which the plaintiff later agreed to. The surgery was carried out on the 1st of August 1984, and after the surgery, there seemed to be no improvement in the bad eye or the right eye, but however, the left eye seemed to develop some amount of inflammation. This was a symptom of sympathetic ophthalmia, which was a very rare risk associated with the operation. The condition robbed her of her vision in the left eye, and with her being nearly blind in her right eye prior to the surgery, Mrs. Whittaker was now left virtually blind. The main issue of the case was related to the defendant's scope of duty and whether there had been a breach in said duty. It is also important to note that the plaintiff had expressed an interest in knowing the outcome of the case and was quite worried something would happen to her good eye. Records show that she was apprehensive that the wrong eye would get operated on, thus showing that she might have rethought the procedure had Dr. Rogers warned her of the implications it might have on her left eye, which makes sense considering her left eye was the reason she could lead a relatively normal life. Following the Boehm's principle, which was discussed earlier, a body of medical practitioners held that they would not have warned the plaintiff of the risk of developing the condition as the risk was too low, and that they would only have answered questions had the plaintiff been learned enough to ask about it specifically, which seems rather unfair considering a layperson would not know to ask those questions. Lord Scarman held that a duty to warn arises from the patient's right to know of material risks, a right which in turn arises from the patient's right to decide for himself or herself whether or not to submit to the medical treatment proposed. In Australia, although it is usually held that the standard of care by a professional with special skills is compared to another professional, moving forward, especially in fields where the disclosure of risk is involved, the Boehm principle has been disregarded as it is important for an individual to have all the information at their disposal when making a decision concerning their life. While it may be helpful to use the standard of care given by other professionals as a guide, the court's rulings will not be based on it. In doing this, the High Court of Australia rejected the paternalistic and practitioner-oriented rulings of the English court and has provided a persuasive directive for the House of Lords and subsequently other courts around the world to follow regarding patient autonomy. From this, we can conclude that although it is relevant to note that while the Boehm test may have been sufficient in the past, as the law grows and the needs of society shifts, informing patients on the risks related to procedures is paramount so that they may make an informed decision regarding their lives. Thank you so much for listening to me, Dr. Hema. With that, I pass it on to the next person.
Moving on, my name is Adriana and I will discuss how Malaysia departed from the Boehm principle in the landmark case of Phu Phio Na and Dr. Su Phuc Mun in 2007. This case is pivotal in understanding the evolution of medical negligence law in Malaysia. As mentioned previously, the Boehm principle, established in Boehm and Fern Hospital Management Committee in 1957, provides that a doctor is not negligent if their conduct aligns with a responsible body of medical opinion. While this test emphasizes deference to professional judgment, it has faced criticism for favoring the medical profession over patient autonomy. Now let's examine the facts of Phu Phio Na according to an article from the Singapore Journal of Legal Studies titled "Doctor Does Not Always Know Best," written by Professor Margaret Fordham. Miss Phu Phio Na, the claimant, was injured when a car in which she was a passenger hit a tree. The most serious of the injuries she sustained was a dislocation of two of her vertebrae with bilateral locked facets, which caused extreme pain to her neck whenever she moved her head. The doctor who treated her immediately after the accident took x-rays and placed a cervical collar around her neck before contacting the first respondent, Dr. Su Phuc Mun, an orthopedic surgeon. Dr. Su advised that the collar should be left in place and that Miss Su should be prevented from moving her head. The next morning, Dr. Su examined Ms. Phu and placed her on a weighted traction to treat the dislocated vertebrae, which proved unsuccessful.
A few days later, he performed a manipulation procedure under general anesthetic in an attempt to unlock the locked facet joint. When after 3 attempts, this also proved unsuccessful. He performed a procedure 5 days later in which he opened Miss Fu's neck surgically at the nape to move the dislocated vertebrae to their original positions, securing them by grafting bone and inserting a wire loop. This procedure also failed. The next day, Miss Fu became paralyzed. Suspecting that the paralysis might be caused by restricted blood supply to the affected area, Dr. Su prescribed a 4-day medication, which was administered by injection. When there was no improvement, he called in Dr. Mohandas, a neurosurgeon. Almost a month later, Dr. Mohandas examined Miss Fu and performed a melogram test. This showed that the paralysis was attributable to the wire loop pressuring the spinal cord. The same day, Dr. Su performed further surgery to remove the loop, but by then Miss Fu was irreversibly paralyzed. At trial, the High Court applied the Bolam test and ruled in favor of the doctor. However, the case progressed to the federal court where a significant shift occurred. The federal court rejected the Bolam principle as the sole standard for determining medical negligence in Malaysia. Instead, it adopted the patient-centric approach outlined in the Australian case of Rogers and Whittaker in 1992. In this case, the High Court of Australia emphasized the doctor's duty to disclose material risks that a reasonable person in the patient's position would want to know. The federal court in Fufiona held that doctors must prioritize patient autonomy by providing adequate information for informed consent. The court reasoned that in modern medical practice, patients are entitled to make decisions about their treatment based on a full understanding of the risks involved. In the words of Chief Judge Siri Norma Yaakob, therefore, there is a need for members of the medical profession to stand up to the wrongdoings, if any, as is the case of professionals in other professions. In doing so, people involved in medical negligence cases would be able to obtain better professional advice, and the courts would be appraised with evidence that would assist them in their deliberations. On this basis, we believe that Rogers and Whittaker tests would be more appropriate and viable tests of this millennium than the Bolam test. To borrow a quote from Lord Wolfe, the phrase "doctor knows best" should now be followed by the qualifying words "if he acts reasonably and logically and gets his facts right." This decision signifies a departure from deferring solely to the medical profession and emphasizes balancing professional expertise with patient rights. It aligns Malaysian medical law with a growing global trend favoring patient empowerment. In summary, Fufiona and Dr. Sufuk Mud marks a critical moment in Malaysia's legal landscape, moving from the Bolam principle to a more patient-centric approach. By adopting the principles from Rogers and Whittaker, Malaysia recognizes the importance of informed consent in safeguarding patient autonomy.
So, in conclusion, from the information that we have researched, it is safe to say that medical negligence in both the United Kingdom and Malaysia has developed so much from the first test, which is the Bolam test, up until Montgomery versus Lanarkshire Health Board. Now, let's take a look back at each point and recap them again. Starting with Bolam test came from the case of Bolam versus Friend Hospital Management Committee 1957. So, this test is to evaluate the standard of reasonable care in negligence cases against doctor. But nonetheless, this test was found not applicable or just in certain situations. Hence, Bolam test is no longer applicable in negligence cases anymore. Now, let's move to Bolito Addendum 1997. So, this case is a refinement of the Bolam test in Bolito versus City and Hackney Health Authority 1997. This has developed the breach of duty. It has restricted the Bolam test by introducing the requirement for medical opinion to undergo judicial review. Now, for Chester versus Afshar, the impact on the Bolam test from the case of Chester versus Afshar has established limitation to the application of the Bolam test involving consent and risk disclosure. Chester versus Afshar has shown that disclosure of risks is distinct from clinical judgment and cannot be solely evaluated through the Bolam case standard of care. Okay, now I'll be talking about Montgomery versus Lanarkshire Health Board. This case is where the Bolam test for consent is replaced with different circumstances due to the nature of the case. Now, This case has successfully overturned the precedent of the standard of care when it comes to informed consent by the ruling of the House of Lords. Since then, multiple cases has been applied to the standard of care of Montgomery. Next is Rogers v. Whittaker 1992. This case is a landmark case for the Australian High Court, departing from the Bolam's principle and sets a precedent that applies in the fields of non-disclosure of risk and provision of advice and information. Fu Fiona vs. Dr. Su Fuk Moon is a Malaysia case that departed from the Bolam principle. In this case, the federal court rejected the Bolam principle as the sole standard for negligence in Malaysia and instead adopted the Australian case, which is Rogers vs. Whittaker. With that, we have covered everything in this presentation. For example, Bolam, Bolito, Montgomery, Chester, Rogers, and lastly Fu Fiona. Thank you for listening, and with that, have a good day. Thank you.